Hi, I'm Shannon Miller with the Miller Elder Law Firm. Today we're going to talk about exploitation. And if you've received a copy of this video or if you're watching this video on our YouTube channel, it's either because you have an appointment to talk to either Jenna Fasulo Lapierre or myself about your potential exploitation matter. I know already you've probably had some information taken from you. I want to give you an overview of what to expect for our phone call. And also, if you're kind of just researching exploitation, what is exploitation in Florida and what tools do we have? The good news is that Florida has some of the best exploitation, I think the best exploitation laws to protect seniors and other vulnerable adults than any other state in the United States. So we're very fortunate to be here. We also have the largest growing population of seniors in the United States, so it's appropriate that we should have the best laws. There are actually three things I want to talk about. We're first going to talk about the criminal law, which is Florida Statute 825.103. And that is criminal exploitation. There are actually 7 different ways to define criminal exploitation in that statute. Only one of them, and this is one of the myths that I want to dispel on this during this video, you do not have to be incapacitated to be exploited in the state of Florida. There is one way to define exploitation that does require an inability to know that you should be able to consent to giving your money away. So in that case, if someone was to receive money from you, and they knew or should have known that you lacked the ability to consent to giving that money away, that is one way to define exploitation that actually does require that this person lack capacity to give their money away. That's the only one that requires incapacity. So let me give you another example. This is one of my favorite definitions of exploitation. Let's say that I have an account that has $10,000 in it, and I join someone else as a joint account holder with me. Let's say I join my daughter as a joint account holder with me, and she doesn't make any contributions to that account, but I am older. Let's say I'm in my upper 80s or 90s, and she doesn't make any contributions to the account, but she starts taking money out of that account to pay for her, dental work. That actually, under the definition of exploitation, is in fact a crime. So if I add someone to a joint account and they use those funds not for my benefit, then they can they may have committed the crime of exploitation. So another myth that I like to dispel is this idea of a gift. So getting a gift from someone who is vulnerable is not a defense to exploitation. So, for example, if I give my house to my neighbor, and my neighbor says, "Well, I'm just getting this house, and she wanted to give it to me, so I took it." In fact, that is also exploitation. So, busting some myths here. This idea that if grandma writes a note and says, "This is a gift for you. Here's all my money," you can still have committed the offense of exploitation by accepting that gift. So these are just some basic ideas that some myths that I want to dispel. That exploitation is a very serious offense, and there are several different ways to define it. One of the other myths that I'd like to bust is the idea that if you're an agent under a power of attorney and you actually take someone's money, there's a principal, they draft this durable power of attorney document, and then you're the agent, so you're operating to help that person, and you notice in the document that it says that you as the agent have the ability to gift to yourself. So you use that power of attorney to gift to yourself, and you buy yourself a new car. that is also exploitation, because if you are an agent under that power of attorney, the exploitation statute says you must either use those monies, use that power in a fiduciary fashion, and it must be either in the person's best interest or for the benefit of the principal, the person who's giving the powers away. So exploitation, the definitions are really good. And, very, very, very important that we dispel some of those myths related to exploitation. Now, what if you think exploitation has occurred? And then what are the options? What are the tools that we have in Florida? So I want to talk basically about one tool that is the exploitation injunction. And that allows us to actually freeze assets. So we are able to, once we meet with you, we talk about the situation, we gather our evidence, we're actually able to file a petition with the court without telling the exploiter. We file that petition with the court, and then the judge will enter what's called a temporary injunction order to really freeze the situation. So if there was a joint account holder on the account and they're using the money for themselves and we show the judge proof of that, then the judge can freeze that joint account down. And remember, we haven't had to tell that exploiter. And then also the judge can enter that order that says, as well, that joint account holder who's been taking the money from grandma can't have contact with grandma. So it's great, because then we have this opportunity to remove the exploiter from the situation, get grandma back on track, and then we will have a final hearing on the matter. And we'll talk more about that during the call. But the exploitation injunction has been really a lifesaver for so many people in Florida. It's only been around since for a couple years now, and we've really loved it. It's been such a great way to save the assets from going out the door. It also creates a lot of opportunity for the judge at that final hearing to do some creative things. So we're very happy with it. Now, what are some of the other options that we have in Florida? We also have something called civil theft. And civil theft is a way to use that criminal definition of exploitation. So what we do is we may send a letter out to the exploiter saying, we know you stole, $10,000 from grandma. You need to give it back. Or if you don't give it back within the next 30 days, we get $30,000 back. So we get treble damages. And that's another opportunity for us to be able to use these amazing laws that we have to really encourage people to not keep the money. Usually that treble damage is a good enough hammer that many people who can kind of see the writing on the wall to send the money back, which is ultimately, we want to get that money back in grandma's hands. So those are just a few things. I'm trying to think what else we might want to talk about. Oh, make sure you have your evidence ready. So if you're getting ready for a call with us and you have a great story about what happened, but you don't have any evidence, we're probably going to say well, this is a great story, but we need to see some evidence. So, things like bank statements, bank records, if there are witnesses who can corroborate the facts, come prepared with their names, their phone numbers, their addresses, so that we can, make sure that we don't go into court without having that evidence to provide to the court. So we like to get all of our ducks in a row, and the best place to start doing that is in that initial conference. So I look forward to talking to you and helping you with this exploitation situation. It's unfortunately, it's a real problem. We know that 1 in 5 seniors over the age of 70 has been exploited or scammed. And those, the average scammer gets $17,500. The average caregiver exploitation is $52,500. So exploitation is epidemic, and we are lucky in Florida that we have the tools to either stop it before it starts or prevent it from getting worse. So I'm Shannon Miller, and I look forward to talking to you. Thank you.